Brown v. Illinois, Supreme Court, 1975. Justice Blackmun delivered the opinion of the court. This case lies at the crossroads of the Fourth and Fifth Amendments. Petitioner was arrested without probable cause and without a warrant. He was given, in full, the warnings prescribed by Miranda v. Arizona in 1966. Therefore, while in custody, he made two inculpatory statements. Thereafter, while in custody, he made two inculpatory statements. The issue is whether evidence of those statements was properly admitted or should have been excluded in petitioner's subsequent trial for murder in the state court. Expressed another way, the issue is whether the statements were to be excluded as the fruit of the illegal arrest or were admissible because of the giving of the Miranda warnings sufficiently attenuated the taint of the arrest. 1. As petitioner Richard Brown was climbing the last of the stairs leading to the rear entrance of his Chicago apartment in the early evening of May 13, 1968, he happened to glance at the window near the door. He saw, pointed at him through the window, a revolver held by a stranger who was inside the apartment. The man said, "Don't move, you are under arrest." Another man, also with a gun, came up behind Brown and repeated the statement that he was under arrest. It was about 7:45 p.m. The two men turned out to be Detectives William Nolan and William Lenz of the Chicago Police Force. It is not clear from the record exactly when they advised Brown of their identity, but it is not disputed that they broke into his apartment, searched it, and then arrested Brown, all without probable cause and without any warrant when he arrived. They later testified that they made the arrest for the purpose of questioning Brown as part of their investigation of the murder of a man named Roger Corpus. Corpus was murdered 1 week earlier on May 6th with a .38 caliber revolver in his Chicago West Side second-floor apartment. Shortly thereafter, Detective Lenz obtained petitioner's name, among others, from Corpus's brother. Petitioner and the others were identified as acquaintances of the victim, not as suspects. On the day of petitioner's arrest, Detectives Lenz and Nolan, armed with a photograph of Brown, and another officer arrived at petitioner's apartment about 5 p.m. While the third officer covered the front entrance downstairs, the two detectives broke into Brown's apartment and searched it. Lenz then positioned himself near the rear door and watched through the adjacent window, which opened onto the back porch. Nolan sat near the front door. As both officers held him at gunpoint, the three entered the apartment. Brown was ordered to stand against the wall and was searched. No weapon was found. He was asked his name. When he denied being Richard Brown, Detective Lenz showed him the photograph, informed him that he was under arrest for the murder of Roger Corpus, handcuffed him, and escorted him to the squad car. The two detectives took petitioner to the Maxwell Street police station. During the 20-minute drive, Nolan again asked Brown, who was then sitting with him in the backseat of the car, whether his name was Richard Brown and whether he owned a 1966 Oldsmobile. Brown alternately evaded these questions or answered them falsely. Upon arrival at the station house, Brown was placed in the second-floor central interrogation room. The room was bare except for a table and 4 chairs. He was left alone, apparently without handcuffs, for some minutes while the officers obtained the file of the Corpus homicide. They returned with the file, sat down at the table, one across from Brown and the other to his left, and spread the file on the table in front of him. The officers warned Brown of his rights under Miranda. They then informed him that they knew of an incident that had occurred in a pool room on May 5th when Brown, angry at having been cheated at dice, fired a shot from a revolver into the ceiling. Brown answered, "Oh, you know about that." Lenz informed him that a bullet that had been obtained from the ceiling of the pool room had been taken to the crime laboratory to be compared with bullets taken from Corpus's body. Brown responded, "Oh, you know about that too." At this point, it was about 8:45 p.m., Lenz asked Brown whether he wanted to talk about the Corpus homicide. Petitioner answered that he did. For the next 20 to 25 minutes, Brown answered questions put to him by Nolan as Lenz typed. This questioning produced a 2-page statement in which Brown acknowledged that he and a man named Jimmy Claggett visited Corpus on the evening of May 5th, that the three for some time sat drinking and smoking marijuana, that Claggett ordered him at gunpoint to bind Corpus's hands and feet with a cord from the headphone of a stereo set, that Claggett, using a .38 caliber revolver sold to him by Brown, shot Corpus 3 times through a pillow. The statement was signed by Brown. At 9:30 p.m., the two detectives and Brown left the station house to look for Claggett in an area of Chicago Brown knew him to frequent. They made a tour of that area but did not locate their quarry. They then went to police headquarters where they endeavored, without success, to obtain a photograph of Claggett. They resumed their search. It was now about 11 p.m., and they finally observed Claggett crossing at an intersection. Lenz and Nolan arrested him. All four, the two detectives and the two arrested men, returned to the Maxwell police station about 12:15 a.m. Brown was again placed in the interrogation room. He was given coffee and was left alone for the most part until 2 a.m., when Assistant State's Attorney Crilly arrived. Crilly, too, informed Brown of his Miranda rights. After a half-hour's conversation, a court reporter appeared. Once again, the Miranda warnings were given. Brown gave a second statement, providing a factual account of the murder substantially in accord with his first statement, but containing factual inaccuracies with respect to his personal background. When the statement was completed at about 3 a.m., Brown refused to sign it. An hour later, he made a phone call to his mother. At 9:30 that morning, about 14 hours after his arrest, he was taken before a magistrate. On June 20th, Brown and Claggett were jointly indicted by a Cook County grand jury for Corpus's murder. Prior to trial, petitioner moved to suppress the two statements he had made. He alleged that his arrest and detention had been illegal and that the statements were taken from him in violation of his constitutional rights. After a hearing, the motion was denied. The case proceeded to trial. The state introduced evidence of both statements. The jury found petitioner guilty of murder. He was sentenced to imprisonment for not less than 15 years nor more than 30 years. On appeal, the Supreme Court of Illinois affirmed the judgment of conviction. 2. In Wong Sun, the court pronounced the principles to be applied where the issue is whether statements and other evidence obtained after an illegal arrest or search should be excluded. We stated, "We need not hold that all evidence is fruit of the poisonous tree simply because it would not have come to light but for the illegal actions of the police. Rather, the more apt question in such a case is whether, granting establishment of the primary illegality, the evidence to which instant objection is made has been come at by exploitation of that illegality, or instead by means of sufficiently distinguishable to be purged of the primary taint." The exclusionary rule thus was applied in Wong Sun primarily to protect Fourth Amendment rights. Protection of the Fifth Amendment right against self-incrimination was not the court's paramount concern there. To the extent that the question whether defendant Toy's statement was voluntary was considered, it was only to adjudge whether it was sufficiently an act of free will to purge the primary taint of the unlawful invasion. 3. The Illinois courts refrained from resolving the question, as apt here as it was in Wong Sun, whether Brown's statements were obtained by exploitation of the illegality of his arrest. They assumed that the Miranda warnings by themselves assured that the statements, verbal acts as contrasted with physical evidence, were of sufficient free will as to purge the primary taint of the unlawful arrest. Wong Sun, of course, preceded Miranda. Although, almost 90 years ago, the court observed that the Fifth Amendment is in intimate relation with the Fourth, the Miranda warnings thus far have not been regarded as a means either of remedying or deterring violations of the Fourth Amendment rights. Frequently, as here, rights under the two amendments may appear to coalesce, since the unreasonable searches and seizures condemned in the Fourth Amendment are almost always made for the purpose of compelling a man to give evidence against himself, which in criminal cases is condemned in the Fifth Amendment. The exclusionary rule, however, often utilized to effectuate the Fourth Amendment, serves interests and policies that are distinct from those it serves under the Fifth. It is directed at all unlawful searches and seizures, and not merely those that happen to produce incriminating material or testimony as fruits. In short, exclusion of a confession made without Miranda warnings might be regarded as necessary to effectuate the Fifth Amendment, but it would not be sufficient fully to protect the Fourth. Miranda warnings and the exclusion of a confession made without them do not alone sufficiently deter a Fourth Amendment violation. Thus, even if the statements in this case were found to be voluntary under the Fifth Amendment, the Fourth Amendment issue remains. In order for the causal chain between the illegal arrest and the statements made subsequent thereto to be broken, Wong Sun requires not merely that the statement meet the Fifth Amendment standard of voluntariness, but that it be sufficiently an act of free will to purge the primary taint. Wong Sun thus mandates consideration of a statement's admissibility in light of the distinct policies and interests of the Fourth Amendment. If Miranda warnings, by themselves, were held to attenuate the taint of an unconstitutional arrest, regardless of how wanton and purposeful the Fourth Amendment violation, the effect of the exclusionary rule would be substantially diluted. Arrests made without a warrant or without probable cause for questioning or investigation would be encouraged by the knowledge that the evidence derived therefrom could well be made admissible at trial by the simple expedient of giving Miranda warnings. Any incentive to avoid Fourth Amendment violations would be eviscerated by making the warnings, in effect, a cure-all, and the constitutional guarantee against lawful searches and seizures could be said to be reduced to a form of words. It is entirely possible, of course, as the state here argues, that a person arrested illegally frequently may decide to confess as an act of free will unaffected by the initial illegality. But the Miranda warnings alone and per se cannot always make the act sufficiently a product of free will to break, for Fourth Amendment purposes, But the Miranda warnings alone and per se cannot always make the act sufficiently a product of free will to break, for Fourth Amendment purposes, the causal connection between the illegality and the confession. They cannot assure in every case that the Fourth Amendment violation has not been unduly exploited. While we therefore reject the per se rule, which the Illinois court appears to have accepted, we also decline to adopt any alternative per se or but-for rule. The petitioner himself professes not to demand so much. The question whether a confession is the product of a free will under the Wong Sun case must be answered on the facts of each case. No single fact is dispositive. The workings of the human mind are too complex and the possibilities of misconduct too diverse to permit protection of the Fourth Amendment to turn on such a talismanic test. The Miranda warnings are an important factor, to be sure, in determining whether the confession is obtained by exploitation of an illegal arrest, but they are not the only factor to be considered. The temporal proximity of the arrest and the confession, the presence of intervening circumstances, and, particularly, the purpose and flagrancy of the official misconduct are all relevant. The voluntariness of the statement is a threshold requirement, and the burden of showing admissibility rests, of course, on the prosecution. 4. Although the Illinois courts failed to undertake the inquiry mandated by Wong Sun to evaluate the circumstances of this case in light of the policy served by the exclusionary rule, the trial resulted in a record of amply sufficient detail and depth from which the determination may be made. We conclude that the state failed to sustain the burden of showing that the evidence in question was admissible under Wong Sun. Brown's first statement was separated from his illegal arrest by less than 2 hours, and there was no intervening event of significance whatsoever. In its essentials, his situation is remarkably like that of James Wah Toy in Wong Sun. We could hold Brown's first statement admissible only if we overrule Wong Sun. We declined to do so. And the second statement was clearly the result and the fruit of the first. The illegality here, moreover, had a quality of purposefulness. The impropriety of the arrest was obvious. Awareness of that fact was virtually conceded by the two detectives when they repeatedly acknowledged in their testimony that the purpose of their action was for investigation or for questioning. The arrest, both in design and in execution, was investigatory. The detectives embarked upon this expedition for evidence in the hope that something might turn up. The manner in which Brown's arrest was effected gives the appearance of having been calculated to cause surprise, fright, and confusion. We emphasize that our holding is a limited one. We decide only that the Illinois courts were in error in assuming that the Miranda warnings, by themselves, under Wong Sun, always purge the taint of an illegal arrest.